welcome all of you to the inaugural Gumzo La ADR conference. Today, my Lord Chief Justice, we begin a journey of 5 days dedicated to nothing but to reimagining and positioning ADR as the preferred dispute resolution mechanism for Africa.
My Lord, CJ, you recall during your tenure as principal judge, you together with the Honorable Justice Owiny-Dollo, drawing from the recommendations of the Justice Butera Committee report on case backlog, agreed to implement one of the key recommendations in that report. And the key recommendation was re-engineering ADR. And indeed, as principal judge at the time, followed this recommendation to where we are today.
This conference actually comes at a particularly meaningful moment for Sweden's work in Uganda. Just last week, we celebrated the official launch of Phase 2 of our Community Justice Program, which is implemented in partnership with the International Development Law Organization, IDLO, here present today. Through the program's first phase, Sweden has supported several key alternative dispute resolution mechanisms. These include the advancement of plea bargaining, the strengthening of community mediation, and the use of the small claims procedure within the courts.
Today, we are now increasing the alignment. What I'm talking about is that everything starts with a nucleus. And once that nucleus, or what you call the core, now we need to expand it. And that is why we have this Gumzo. This is an extremely ambitious initiative. Now, as we leave at the end of the week, let us all become step-down transformers. When we speak of ADR, some people think it is a very complex thing. So let us simplify it the way a transformer steps down a high voltage current to a level that it can be used even for charging a telephone and at the same time for running a factory.
ADR has been identified as an effective strategy for managing caseload and reducing case backlog. Colleagues, you know that actually courts don't resolve disputes, they just decide cases. Disputes are resolved by ADR. That's why even after you have handed over a judgment, someone will want to appeal, meaning that although you have handed over a judgment, someone is not satisfied. The dispute has not been resolved. But how many people appeal ADR decisions? No one, because you have resolved the dispute. You have not decided the case.
We need to market ADR to government of resolving disputes. But we now need to walk the talk. It's a new thing. We've been used to the adversarial system. Marketing ADR will therefore require a strategic shift towards ADR by convincing government that ADR reduces litigation costs. Government spends a lot of money on litigation.
What we need to do is to allow the parties, every time they are in the courts and they get a better understanding of their disputes, a better understanding of the rules, the laws, the facts, as they go through the court system, to re-evaluate a possibility of negotiating again. In other words, this story that we have done negotiation and it failed, so we must move forward with litigation, has now been debunked. Continuously talk until a resolution is obtained.
We are getting applications for mediation from very senior firms, from the Attorney General, from the banks, from the URA, and a number of other common litigants in that court. So I think let's emphasize training. It will do miracles.
So let me say on behalf of the organizers to thank you for being part of the first inaugural Mediation Gumzo. Thank you so much.